Good morning, at least a sunny day here in Buffalo. It's good to see everyone virtually. For those who don't know me, I'm Henry Sommerfeld. I'm the incoming president of the UB Law Alumni Association Gold Group. We're grateful for your attendance this morning for the CLE presentation titled Transparency is Key: From Job Postings to Notice Requirements, How Employers Must Be More Transparent Than Ever. And I'm grateful to both of my colleagues from Hodgson Russ, Kinsey O'Brien and Tom Grenke, whom my colleague Earl Cantwell will introduce momentarily, but they'll be speaking this morning. And this is one of a number of virtual programs in a series that the Law Alumni Association and the Gold Group hosts as a service for our alumni and our law students. If you're interested in attending any of our upcoming webinars and CLEs, you can register on the UB Law website, law.buffalo.edu/alumni events. Check that website out, see what we are offering. There's quite a diverse sense of CLEs and webinars that should be of interest to you in your practice. You can also listen to past CLEs and other webinar recordings at no charge on the alumni education page, which is another benefit, which is also located on the law school website. To get discounts and select free 1-hour CLEs, please consider becoming either an annual or a lifetime member of the UB Law Alumni Association if you aren't already. Finally, I'd like to thank our Gold Group sponsors who have helped to underwrite the costs associated with these events. We cannot do what we do without our sponsors, so we're certainly grateful. Our sponsors this year are Chicago Title, Counsel Press, Equitable Advisors, Jack W. Hunt and Associates, and Precision Resolution LLC, Paramount Settlement Planning LLC. So thank you again to those sponsors. Just a few brief administrative points before we get started this morning. You will be muted during the course of the presentation. If you have questions, please use the chat. We will be monitoring those, and those questions will be addressed most likely at the end. At some time during the CLE, there will be a course code that you need in order to get CLE credit. It will be announced. It will also be placed in the chat. This will be probably about halfway or so through the CLE, so please be sure to catch it. You'll need this for the verification that's available online, along with the materials. If you haven't downloaded them already, they're on that website page. And with that, I will turn it over to my board colleague, Earl Cantwell, to introduce the speakers more formally. Thank you.
Hey, thanks, Henry. It's my pleasure to introduce our two presenters today, Kinsey O'Brien and Tom Grenke. So Kinsey represents and advises private and public employers in all aspects of employment law. She regularly counsels employers on compliance with federal wage and hour laws, worker misclassification issues, inclusive hiring and employment practices, including leave and accommodation management, avoidance of discrimination, harassment, and retaliation claims, discipline and discharge, and workplace policies and handbooks. Working with her clients as a strategic business partner, Kinsey helps management and human resources professionals mitigate risk through all phases of the employment relationship. And Tom Grenke is also a member of Hodgson Russ's labor and employment practice, where he represents private and public sector employers in all aspects of labor and employment law. I will hand it over then to Kinsey and Tom to get us started.
Thanks, Earl, and good morning, everyone. On behalf of both Tom and myself, I want to voice our gratitude for both the Law Alumni Association and the Gold Group inviting us to speak on this topic today. And what we're really going to be talking about, as outlined on our agenda here, is the way New York State has been developing through legislation a real culture of transparency as between employers and employees. Employers have greater and greater obligations to be transparent with their employees in New York State. And today we're going to cover just 3 examples of that. These are far from the only examples, but they are 3 brand new, really important legal developments. And we're going to really devote primary focus to the pay transparency law that relates to disclosure of compensation and other information in job advertisements. Before we dive in to that topic, I think it's helpful to think about this culture of transparency, and particularly pay transparency, in the historical context. And we'll see in a moment how it really does have roots in what may be some unexpected places. From there, we're going to look at local and the New York State pay transparency laws. With respect to the New York State pay transparency law, as is so frequently the case in the world of employment law, which is fast moving, fast developing, these materials that we just prepared are already out of date. There have been some amendments to the law that in some way expands and some ways narrows the scope of application. So we'll point out as we go through the materials today, those areas where our slides reflect the prior version of the law, which has now been amended. And then finally, we're going to close with the new requirements around notice to employees of electronic monitoring, as well as requirements to provide electronic versions of workplace postings that have traditionally been posted physically at the work site. So pay transparency, how did we get here? I'm going to start with a law that was enacted in 1935. The National Labor Relations Act. Under Section 7 of the Act, employees have, among other rights, the right to engage in protected concerted activity, to work together to better their lot as employees, to better their terms and conditions of employment. And that right has been interpreted to include a right to openly discuss and even complain about wages, benefits, working conditions, and the like. So employees have long had the right to be, if you will, transparent with each other. It has long been unlawful to require a non-supervisory, non-managerial employee to keep their compensation confidential. And that is true regardless of union status. It applies to both unionized and non-unionized employees. New York State, not to be left out of the wage discussion fun, did amend Section 194 of the labor law several years ago. Section 194 is the New York State Equal Pay Law, and it was amended to include the language here that no employer shall prohibit an employee from inquiring about, discussing, or disclosing the wages of that employee, of their own wages, or that of another employee. So from there, continuing in our historical context, I think we have to look at the Me Too and the Time's Up movements. And you might say, Kinsey, why are we talking about Me Too and Time's Up? Didn't those really have to do with sexual harassment in the workplace? And they certainly did. And in fact, those movements led to some pretty substantial changes here in New York State in terms of our laws around sexual harassment and other forms of discrimination. That is where we got our now tried and true requirements to have sexual harassment prevention policies, to provide annual sexual harassment prevention training. It's where we got some pretty dramatic changes in the standard and defenses that apply to harassment claims under the New York State human rights law. So that was the genesis of those movements. But I think many of us employment law practitioners saw the writing on the wall and believed for some time that that was really the first phase, and that the activists behind those movements would be turning their attention to pay equity, to trying to eliminate the wage gap, the perceived wage gap for employees based on gender and other unlawful protected classifications. And that movement, as I've kind of seen it unfold, has really been three-pronged. It's been, can we look at expanding pay equity laws? Can we look at banning employers from inquiring about or using an applicant's salary or wage history? And then finally, enacting pay transparency laws. And this movement has been incredibly successful in New York State on all three of these prongs. We have had major legal developments in all of those areas. And what we've seen, which I've found to be quite interesting, is that on the more novel concepts, the things that are really kind of new to the legal landscape for employers in New York, particularly the salary inquiry and use bands and pay transparency, localities have kind of led the way, in as much as we'll have a local law that's adopted and then state legislation to mirror or at least somewhat mirror that law. We saw that with the salary history inquiry ban, and we're seeing that again, albeit with a very limited lead time for pay transparency. So I want to just talk a little bit about the other areas where these pay equity movements have been successful in New York. The first, as I mentioned, expansion of the state pay equity law. It may surprise some of you to know that before October 2019, New York State's pay equity law only prohibited sex-based pay differentials. Now, it certainly could have been possible for a claimant who was subject to, say, a race-based pay differential to make a claim under a different provision of New York law, such as the human rights law, but not under Section 194 of the labor law. That was changed in October 2019 through legislation that expanded these equal pay protections to all protected classifications under the human rights law. So that includes, of course, age, race, color, creed, religion, national origin, also includes sexual orientation, gender identity, disability, some, maybe more surprising or unique ones, predisposing genetic characteristics, familial status, domestic violence victim status. So these equal pay protections are now available to anyone falling under any of these protected classifications. And the legislation also reduced the burden on an employee, making it likely a little bit easier to pursue and prevail on a pay equity claim. So that was the first wave. Second wave, the salary history ban. This one is, despite the fact that it went into effect in 2020, I still find, and perhaps it's because we've lived through a global pandemic since, and employers rightfully had other things on their mind. But this is something that I still find employers to sometimes be unaware of. So when you're working with your clients, or when you're working on hiring for your own firm or organization, absolutely something to be on the lookout for. What this law effectively does is prohibits an employer from asking about, verbally or in writing, an applicant's salary or wage history. That's both for new employment as well as a current employee seeking a transfer or a promotion. It also prohibits the employer from relying on that same kind of information, salary or wage history, to determine whether to make an offer or determine the wages or salary that will accompany that offer. So the idea here is that, we have, in our culture, perhaps some systemic pay discrimination is the theory of the legislation, and that by prohibiting employers from relying on perhaps past depressed wages, we don't allow employers to further that cycle. There are some exceptions to that law. We've included a summary of them here in your materials, but suffice it to say they are quite limited. And that really the advent of this law means that as New York State employers, we need to be setting salary, wage information and making those decisions really based on the position itself, as well as perhaps the bona fide qualifications of the applicant, but not the applicant's prior compensation. So now we're in, the third wave of what I view as this kind of post Me Too, post Time's Up set of developments. And as we said earlier, localities have led the way a little bit, but with very limited lead time. And I'm going to turn it over to Tom to discuss some local pay transparency laws that really have just now taken effect, and we'll all get to experience life under those to the extent we have employees in those jurisdictions, or our clients have employees in those jurisdictions for a few months until the state law goes into effect. So I'll turn it over to Tom.
Thanks, Kinsey. Good morning, everybody. And as Kinsey mentioned, this seems to be this wave of transparency, or most recent wave of transparency, really seems to start at the local level, and perhaps one of the biggest local levels in the world, and at least in our state alone, would be New York City and their recent pay transparency law, which took effect back in November of 2022. And it amended the New York City human rights law, but it still seemed to have, as Kinsey mentioned, there was a lack of a lead time. It scared of a lot of employers right away, but there've been some changes made over time that has really defined it and given us more of an understanding that you can provide and provide to your clients and in your practice as well. So generally speaking, the law requires that employers provide, and I'm quoting here, a good faith salary range for any job promotion, application or transfer that is advertised in general. So we'll get into what a good faith is and what a salary range is, but at least from the get-go, a covered employer is an employer with 4 or more employees or 1 or more domestic worker. It's important to note that all of those employees or 4 employees do not need to be in the same location. They do not all need to be in New York City. Just one of them needs to be in New York City in order for the employer to be covered. We see this a lot with out-of-state employers who may have an employer who's located in New York, or even an out-of-country employer who has 1 worker located in New York City. Also, kind of some smaller nuances to the law. Employment agencies are covered under the New York City pay transparency law, but temporary agencies are not. The difference being is that an employment agency would, in theory, have a job that lists, the description, the salary as well, and they're going out and soliciting candidates, whereas a temporary agency would just be really soliciting employees and then placing them at various locations. But the employer who works with the temporary agency would be covered under the New York City pay transparency law. That last bullet there perhaps is the continuing nuance issue that we have, is that it does not apply to advertisements for jobs that cannot or will not be performed, at least in part, in New York City. In today's world, post-COVID, in the maybe hybrid work model or remote jobs, it's still a little bit developing of how this would apply. For example, you could have a New York State employer that has 1 employee who works hybrid in New York City, but maybe is outside of New York City. In that situation, it would probably be that the law would apply, but we're still waiting for additional guidance and maybe a little bit additional, unfortunately, case law before the New York City Division of Human Rights to really flesh out precisely what this hybrid work or remote work application would be. So what do we mean by advertisement? It's a written description of available job promotion, the job itself, or a transfer that's publicized to a pool of potential applicants. Unique about this law is it would apply even if the job posting is external. So in today's world, that's usually, Indeed, LinkedIn, ZipRecruiter, or maybe on the company's website itself. In those instances, the New York City pay transparency law would apply. But even in internal applications, so say you're an employer and you never even post a job publicly, you just post it internally to your own employees. In that situation, the transparency law would apply. In maybe more of an old-fashioned type of job applications, putting it in the newspaper, maybe a bulletin board at a local community center, in that situation, the transparency law would apply. The law is going to apply regardless of medium, but it would not prohibit or apply to employers from hiring and using an advertising that is not publicized. So I guess word of mouth would be an example, but it seems that in an increasingly digital world, and again, in a post-COVID world where everything seems to be online, it's unlikely, I'll say it that way, that the New York City pay transparency law wouldn't apply if you are a covered employer. So what needs to be included in your advertisement? You must have a minimum and maximum salary threshold, and that is the minimum and maximum salary that you, in a good faith, believe would be the salary at the time of the posting. Again, the good faith standard kind of ruffled a lot of feathers amongst employers. So what precisely does that mean? It means the salary that you believe, or you being the employer believe, would be willing to pay at the time of the posting. Now that could change over time, and I'll get into that a little bit later, but it's at the time that you hit enter, you hit OK, and that job is posted on LinkedIn or Indeed. This is the range that I would be willing to pay an employee who's applying for this job. There has to be a minimum and maximum salary threshold. For example, there's a few examples on the page here that it can't just say $15 and up or a maximum of $50,000. It would have to be $15 to say a maximum of $20, or say $40,000 to a maximum of $50,000. In the event that there isn't any flexibility, there's no minimum or maximum, you can just state the identical amount or the maximum amount and say it's $20 per hour. But we advise that would lock you into not being able to at least go below $20 per hour. So besides having the salary, the minimum and maximum salary that you good faith believe would be applicable at the time, there's certain things that would not need to be included. That include, what the employer's health plan is, what the employer's stance is when it comes to, PTO or unpaid time off of work, 401k contributions, pension plans, overtime availability, or other forms of compensation like tips or bonuses or stock options. Those items do not need to be included in the ad. The ad would just be limited to the minimum and maximum salary threshold that the employer has a good faith belief at the time of creating the ad or creating the advertisement that they would be willing to pay an employee at the time of hire. So the New York City Pay Transparency Law will be enforced by the New York City Commission of Human Rights. In the event that an employee is successful, the traditional damages are available. That can include back pay, compensatory damages, punitive damages, and attorney's fees. However, at the time that the law was enacted, it originally allowed not only existing employees, but also applicants to file a claim. And this upset a lot of employers that it seemingly exposed employers to an endless pool of applicants who could file an administrative action against them before the Commission of Human Rights. They have recently narrowed the law and allowed that there's a right of action for only current employees, which would seemingly eliminate the endless pool of applicants from filing claims against an employer across New York, or across the world, I guess you could say, but at least across New York State. When it comes to assessing penalties, the New York City Commission of Human Rights will be just a little bit flexible, that they will allow a first-time violation to let it slide, essentially, in the event that it's fixed within the first 30 days. But those successive or succeeding violations where it's become problematic, when you have $125,000 for uncured violations, or $250,000 for violations that are found to be willful. And we'll look at a couple examples moving on here. An example would likely be a willful violation. And actually, we'll touch on it right now. When this law originally came out, a lot of employers seemed to act quickly and started throwing out salary ranges. Some of them can be quite ridiculous. If you look at the third bullet point, the Citibank originally offered a position that was between $0 and $2 million was their salary range. They quickly took this posting down. But this would likely be a situation where you have a willful violation of the law. Of course, a $0 to $2 million isn't a good faith salary range. Same thing with the Dow Jones and the New York Post requirements. Those ranges seem to be a little bit broader or wider than I would say a normal salary negotiation would go on. But again, the first violation can be fixed within the first 30 days. It's those additional violations that become problematic. A lot of questions that we seem to experience is when it comes to applicant negotiation. Say, for example, you do have an ad that is your good faith belief that you would pay an employee, say, $40,000 to $50,000 per year, but a really great applicant comes along and you were willing to pay them $52,000. Now, that likely would not violate the New York City Pay Transparency Law, But it would be somewhat problematic if you are willing to pay $40,000 to $50,000, but then you offer an employee, say, $37,000. That's where we see most of the issues lying. But we don't want to advise our clients, and you shouldn't as well, that employers are still allowed to negotiate salaries with incoming or potential employees. That's entirely permitted.
Yeah, and before we move on to the next slide, just a couple kind of additional thoughts here, right? The New York Post, Dow Jones, Citibank just got lambasted in the press for these kinds of broad ranges. The Citibank one, I think is a particularly egregious example, a $2 million swing. And I think that the fact that the company took that down fairly quickly is, reflective of that. But, if you look at the New York Post, Dow Jones, yeah, they're broad, but they don't strike me as, and perhaps this is my, management lawyer bias showing, but they don't strike me as being totally out of the box. And one thing that we've kind of wrestled with and had fun debating internally, right, is if we think about our own practices of law, what if you're hiring, for example, a non-equity partner, right? Someone who is still technically an employee of the firm. The compensation that you're going to pay to that person is going to vary substantially based on a number of factors, probably the primary driver of which is the size of the book of business they bring in. And, perhaps that is, also the case for, certain sales, marketing folks in other industries. So I think this poses some real practical issues of how do you decide the good faith range, and practical issues to which I'm not sure there are really yet any concrete answers because this is so new. I don't think a $2 million range starting at 0 is the answer. But the reality is that the compensation that an employer is willing to pay will be based on factors that are going to be highly variable with the individual applicant. So something to keep an eye on and really think very, very thoughtfully about before you make a post that for which you would accept a New York City applicant. On the negotiation piece, I think Tom hit it right on the head, right? That yes, I think there's still some flexibility there, but remember that this range is what you are in good faith willing to pay for the position. So I don't think like your run-of-the-mill, very good, what we expected and hoped to get candidate is going to be the type that will warrant a substantial deviation from that range. It would have to be like an out of the box, there's no way we could have anticipated somebody this good coming to us to really justify it, because you're saying we're now willing to pay more than we were in good faith when we posted this just recently. Very interesting questions, no solid answers yet, but lots to keep our eye on, and we will undoubtedly see this on the state law side as well. So we'll transition over to that now.
Thanks,
So
Kinsey.
yeah, absolutely. Thanks, Tom. Section 194B.
Hey, Kinsey, can we do the course code real quick?
Oh yeah, absolutely.
Oh, sorry about that. I don't mean to interrupt. I just don't want to forget to do it. The course code is employment. Again, course code is employment, and I will also drop that in the chat, which is needed for the attorney affirmation, which I also put the link in the chat for that as well. Thanks, Kinsey.
Thanks, Emily. So the pay transparency law is now codified in section 194B of the labor law. It really isn't too terribly lengthy. We did include it with your material, so definitely something good to go and take a look at. It will take effect, it is scheduled to take effect on September 17th of this year. So we have a couple months to get ready, about 6 months here, but really not a ton of time. So what this law will require is that employers with 4 or more employees will need to include in any job advertisement the compensation or range of compensation for the job, promotion, or transfer opportunity, and if one exists, the job description for that job, promotion, or transfer opportunity. The job description piece is very interesting to me. That is not present in the New York City law, and really I don't think is present in many of the other local laws that we've seen. You know, some employers do, some employers don't have job descriptions. And I think that it begs the question, right, of do we create one? And if we create one, you know, do we lose any flexibility as an at-will employer to make changes to that job description? Very, very interesting that is included here. Advertisement, as I mentioned earlier, there have been some very recent amendments to section 194B. One of them was to add a definition of advertise, which was previously very conveniently missing from the statute. And that definition is broad. It means to make available to a pool of potential applicants for internal or public viewing, including electronically, a written description of an employment opportunity. So this is pretty similar to the New York City definition that Tom covered. It's certainly going to apply to, you know, your intranet, your internal job boards, traditional want ads. I don't know if anybody is still using those, but if you are still putting things in the newspaper, it's going to apply there, and on places like Indeed, ZipRecruiter, LinkedIn. It will not extend, given the requirement that it be a written description, it will not extend to verbal discussions, right? So if I just call you up and tell you about a fantastic job opportunity at Hodgson Russ, that is not covered, but certainly to the extent I point you to our posting on our website, that posting would be covered. A question in my mind, what about direct emails, right? I email, you know, an old law school friend, hey friend, I really think you should consider putting in an application to come work at my firm. Is that a written description of an employment opportunity that is covered by the law? You know, my initial reaction is maybe not. It's really not, you know, making available to a pool of applicants, but remains to be seen. We have in this slide that these requirements will apply for any job promotion or transfer opportunity that can or will be performed at least in part in New York State. This is now outdated as a result of those amendments. And the amendments in one regard, I think narrowed this, and then in another regard kind of blew the lid off of the thing. So we got rid of the words can or. So it applies not to any job that simply could be performed in New York, right? But to a job that will physically be performed in New York State. That is a lot clearer. That's narrower. We can work with that, right? But then we get the or, right? Or a position that will be performed outside of New York State, but will report to a supervisor, office, or other work site in New York State. And, you know, looking at this, I kind of thought, okay, maybe this makes some sense in as much as we look at where the employee is seated, and then we look at kind of where the physical embodiment of the employer is seated, the supervisor, the office to which the person is reporting. So, you know, I think logically it makes some sense, but I think it presents more questions than answers. And top of mind for me is, you know, how far up does this go? Is it a direct supervisor, or is anybody in the supervisory chain going to pull us into this law, despite the fact that the applicant may never, when performing the job, set foot in New York, may never talk to anybody in New York. It's just that's where HQ is, right? And their supervisor eventually reports up there. Very, very interesting addition to the definition. I think it was intended to be a bit of a compromise between can or will, to you know, give us some, okay, we're going to apply this to out of New York positions that have some tangible connection to New York, but you know, I think that the questions around it remain a bit open-ended. So this will sound familiar to what Tom covered a few minutes ago, right? What do you have to put in here in terms of the compensation? It's really two options. If you've got no flexibility, it's the compensation for the role, $20 an hour, 150 grand a year, the comp. Or what I think will be the much more common approach for employers, the range, the minimum and the maximum. So starting point, midpoint, those types of things are insufficient. It again needs to be the range that you in good faith believe to be accurate at the time of the advertisement. So perhaps there's some room there for upward or downward movement, depending on the applications that come in and the passage of time. But you know, that really needs to be something that you give some good thought to, or your clients give some good thought to before making the post. Interestingly, the legislation expressly provides that for positions that are solely paid on a commission basis, that all you have to do is state payment shall, compensation shall be based on commission. So you don't need to provide any kind of forecast of what those commissions could be on the minimum or the maximum side for a commissions only position. So as originally passed, the legislation required really some fairly open-ended record keeping. It required the employer to maintain records of compliance, including the history of compensation ranges and job descriptions. It didn't clarify how far back you have to go with that history. Didn't clarify how long you had to maintain those records. That requirement has been removed entirely by this new legislation. So section 190, are we talking about 194B, I believe, no longer has record keeping. But as evidenced on this slide, there can be some substantial penalties for failure to comply. You're not going to get the grace period of New York City with the 30 days and we won't hit you with a cost if you fix it. It's mandatory civil penalties of $1,000 for your first violation, $2,000 for the second, and $3,000 for a third or subsequent. And any individual who believes they have been aggrieved by a violation of this law may seek remedies by filing a complaint with the Department of Labor. So at least it's an administrative proceeding as opposed to a court proceeding. But this, again, not like New York City, where we're only applying this to folks who actually get the job. It does seem that endless parade of applicants that Tom mentioned could avail themselves of this complaint mechanism. So what I think that means practically, given the scope of penalties, given the potential for complaints, is that we as employers in the legal industry, and when we're working with our clients, really should be counseling our clients to maintain at least some proof of compliance, right? Maybe you're not going to do some broad-based history, retroactive look on the compensation ranges, but I would think at a minimum, you would want to retain copies of job postings that go out after the law's effective date. As for how long you do that, not entirely clear. I would suggest probably somewhere in the range of 3 years, since that's the state anti-discrimination statute of limitation. But I think that we're hopefully going to get some additional guidance around that at some point before September here. So when the law was enacted, it was enacted with an approval memo, an approval memorandum in which Governor Hochul forecasted us that which has now come to be, that we were going to have some fixes in the legislation to clarify the meaning of job advertisement, to deal with remote opportunities, and to eliminate the record maintenance requirement. So all of that has now occurred. But I think that probably is not the last development before this thing goes live in September. The legislation indicates that the Department of Labor is required to issue rules and regulations under the law. Whether we actually get regulations or perhaps just some guidance, not entirely clear to me. But I think that the New York State Department of Labor will be weighing in, hopefully, with more than a couple days lead time before, hopefully we're not going to get this guidance on, like September 15th or something. But I think we will get some greater clarification, and maybe some of these many open-ended questions that I've been speaking about in a very academic way, maybe we'll get some clarity on those. So with that, I will turn it back over to Tom.
So sticking with our theme of transparency, outside of paid transparency, there's a law that's been on the books for a little while now, since May of 22. It involves employers who electronically monitor their employees. It was an amendment to the New York State Civil Rights Law, and it applies to all private sector employers regardless of size. The key is, if an employer who engages of monitoring or intercepting of an employee's telephone calls, email communication, internet access, or internet usage, this law would apply to you. What it does, it requires employers to provide notice to their employees if they engage in those type of practices. Now, the notice requirement is somewhat twofold, but it can be provided in writing or electronically. And I may lean on the side of providing it electronically for another transparency law, which I'll talk about in a second. But essentially, an employer who engages in this type of monitoring of employees is required to give notice. Now, as I mentioned, the notice is twofold. For existing employees, that would be employees that were employed as of May of 2022, the requirement is fairly simple. The employer has to provide one of those standard style notices informing employees of their practice, of what they're doing, essentially of monitoring their employees, say email, and you post it in the conspicuous place in the workplace. We've always advised clients to put that notice in the same place that you would with the workers' compensation notice, New York Hero, that bulletin board in the lunchroom or the break area where everything else gets posted. Now that would cover existing employees. But new employees that would have become employees, after May of 2022, those employees had to be given a specific notice themselves, notifying them of the employer's practice. Again, we felt it was best practice to maybe give it to your employees or give it to your client's employees when the employee gets the employee handbook and they sign off and they say, I received the employee handbook. I read everything in here. Oh, in addition to that, I also read this section 52C of the Civil Rights Law notice letting them know that, oh, my employer is monitoring my telephone calls. They're monitoring my emails. I received this piece of paper and you signed it off there. That would satisfy the requirements under the law, under the notice law. Couple nuances. Go ahead.
I just want to highlight something you said, right? I think that best practice is probably to do it as a separate written acknowledgement. I think including this notice as part of your handbook, many of our clients do that within a broader kind of electronic communication system policy that talks about acceptable use of IT resources. And I think that that's a good approach, but I think the best practice is probably to at least have the acknowledgement either be separate or at a minimum call it out within the broader handbook acknowledgement.
Yep, I think it's a great point. A couple nuances. The law does not prohibit employers from engaging in those type of practices. It just requires that employers notify their employees of the practice. And again, that's where specific email communications, telephone communications are being monitored. The law does not apply to various cybersecurity, I'll call them as a general term, that may be, managing the volume or the type of incoming emails for potential spam or malicious actors. That would not apply. Or it's not targeted to monitor or intercept electronic activities of a particular individual. Or for, say, system maintenance. The law would apply and the notice would have to be given when there's a generalized employer practices of collecting everybody's emails and then reading through them to monitor what's going on in the workplace. That's when the notice is triggered. Again, as Kinsey mentioned, having a general notice or simply notifying the employees that the practice could happen may be a way to protect from potential actions. As it's mentioned here at the end, the Attorney General has the exclusive authority to enforce this law. And there could be civil penalties of $500 for the first offense, $1,000 for the second, and $3,000 for each for each offense thereafter. But again, like the New York State pay transparency law, and unlike the New York City pay transparency law, there is no private right of action for employees to enforce this law.
Yeah, and while this statute itself is new, right? I think the practical advice of you should have some clear disclaimer somewhere in writing around your monitoring practices is something that we have recommended for many years. I mean, if nothing else, from like a federal wiretapping perspective, to the extent you're recording phone calls, right? I'm not a criminal defense lawyer, but I would think you probably want to stay far away from that. So I don't think that this changes practically the overall strategy of what you're doing, but it really is, I think, kind of a new paperwork requirement, and that there's very particular language that you now have to use, and the requirement for the acknowledgement.
And there could be a situation where an employer is already monitoring their employees, maybe not actively doing so, where there's, somebody's in a dark room somewhere flipping through everybody's emails. But I know Kinsey and I experience it a lot, where perhaps maybe an entirely separate issue comes up, where there's maybe a harassment claim, and they happen to be collecting all of these emails already. And, Kinsey and I are saying, hey, what is Jane Doe saying to John Doe? And all of a sudden, boom, it finds out or the employer is monitoring employees, but they don't have the notice in there. That is potentially a catch-22 in a problematic situation for employers. So having that, as Kinsey mentioned, a paperwork notice is definitely another best practice. So our last of the transparency laws, another one regards electronic posters. So this one again mentions or amends the New York labor law. And as I mentioned before, I'm talking about that bulletin board in the lunchroom or the bulletin board in the break room that's got all of those posters all over. It could be the notice that you're monitoring employees, or your workers' compensation, or the New York State HERO Act, or whatever it may be. Those are now required to be electronically provided to employees. That could be provided to employees on a shared intranet. Could be provided to employees via email, or when they first originally start with the company. But there's now a requirement that these notice posters be electronically provided to employees. One of our partners in our group came up with a good idea. When an employer hires a new employee and they're providing them with all their paperwork, their I-9s, their handbooks, the whole shebang, is that at that time it may also be beneficial to also include all of those various different posters to make sure you cover your bases. I think in our, as I mentioned before, our increasingly electronic and post-COVID world, there's many times an employee may never be in the workplace. So the theory behind the law is, an entirely remote employer may not know who to call if they have an issue with workers' compensation or whatever, because they've never seen that bulletin board. They've never been in that lunchroom. So there's now this electronic requirement that this be provided to those type of employees, or just to employees in general. I think that's it. We have Kinsey for our wave of transparency.
Yeah, so the electronic posting, it seems like a minor piece, right? But when we think about it from like the transparency lens, right? The postings physically were already a way of, dear employee, here are the many things we as your employer are obligated to do, and here are the ways you can make complaints about us. That's pretty radical transparency. And it's long been a physical requirement. It's now an electronic requirement as well. So as I mentioned at the outset, these are just three, I think, high profile and very recent examples of employer transparency obligations. I certainly could spend time thinking about others. One that comes top to mind is, your Wage Theft Prevention Act notices, where at the time of hire, you have to provide notice regarding pay rate information and payday information. So lots of things to think about here. But with that, we will turn to any questions.
All right, Kinsey, I have a question in the chat here, and the question comes back from when we were discussing not looking at or basing compensation for like an internal applicant applying for a promotion within a company. And the question was basically, is in those circumstances, is the employer required to pretend that it doesn't know the current comp of the internal applicants?
Yeah, that's a great question. Seth, thanks for putting it in the chat. This is a question I've been getting since 2020, and I'm still not sure that we have a firm answer on it. I think very practically, right, we have as the employer the scope of information that we have, and even if we don't, look at it, think about it, the fact that it's accessible to us, I think means that someone could argue we looked at it and thought about it. And I think the most elegant way I've been able to come up with to solve for that, right, is we can't put our heads in the sand. We can't pretend we don't know that information, but we should be setting the comp for that other position based on the factors relevant to that position. How important is it in the organization? Is it a high money making position that really brings us a lot of funding, right? Is it something that's critical? Is it a management role? So really kind of think about job related criteria, and, perhaps some person related criteria, right? Is this person a good worker? How long have they been with us? What's their education and background? But to try and focus more on like the job criteria, it's a really sticky situation, and I wish I had a clearer answer for you.
What about Kinsey as well, keeping in mind that maybe this job is only being posted internally at that time, and you do set the range, but keeping in mind that, this job may be posted externally for whatever reason. That applicant doesn't want the job, that applicant needs to move, and all of a sudden now you're locked into a specific range that you might not be able to get out from if you need to, say, increase it or decrease it if you go to the public.
Yeah, I think that's a really interesting point, right? At the intersection of these two laws, one that's been in effect for a couple of years and one that's coming right now, right? Is that you may open up to internal applicants for a period of time, but then also do an external call. And I think where that's going to be the case, or where you think that's going to be the case, I would probably think through what's the range that we're going to put in the external posting and apply that same range for your internal candidates when you're thinking about, are we going to offer to this internal applicant? Great point, Tom.
Hi, Kinsey and Tom. Thanks for the great presentation. I just had a question, and I think it's pretty clear from the statute, but wasn't aware of the recent amendment of 194B until you brought it to my attention this morning, and then I took a look at it. It still seems to me that as opposed to 194A, 194B explicitly does not apply to governmental employers. I just wanted to confirm, or see if you had any different thoughts on that.
Let me just go to my handy, unless Tom knows the answer off the top, I'm going to flip to the statute.
I believe that's correct, but
I think
flipped
that's
it
right.
in front of me.
Yep, it looks like that is right. Yeah, I believe that's right, Heather.
Thank you.
Yeah, no problem.
It just really struck me that like the same section, 194 has two different definitions. So it was something that was sort of bugging me, and I don't see a change in the amendment that I can access online right now, at least.
Yeah, I think that's right. And I think that the way I read that, right, is that we're going to prohibit, government actors from discriminating, but we're not going to require them to do this, kind of affirmative transparency piece. That seems to be the message.
Which would, with civil service applying to many government employees, it would really complicate things. So that makes sense. Thank you for the clarification.
Yeah, no problem.
Other questions or comments? All right, seeing none. Thank you, Kinsey, and thank you, Tom. This was an insightful presentation, and while I don't have to deal directly with it, I'm sure many in this group do. So it's a timely topic that continues to evolve. So thanks for sharing your expertise and insight on this ever-growing issue. Thank you to both of you. Thank you to everyone for attending. Reminder again, don't forget to get online and submit your attorney verification to get your credit. And if there are any issues, you can email me or email Michelle Miasi. And otherwise, we will see you at the next CLE or the next in-person alumni event. Enjoy the sun if you're in Buffalo or Florida. Take care.
Thank you.